Welcome to Court Docket.
A man accused of beating a special needs child walked into Judge Stephanie Boyd's courtroom believing his 8-year plea deal would end the case. But everything changed when the judge asked one simple question. Why did you do it? Instead of taking responsibility, he blamed the child. What happened next stunned the courtroom. Judge Boyd tore apart every excuse, exposing the truth behind his actions and delivering a devastating reality check. By the time the hearing was over, his excuses were gone, and so was any hope of sympathy. Here's what happened inside the courtroom.
Calling 2025 CR 005302 and 2025 CR 005304, State versus Jesus Guadalupe Navarro. Could I have parties announced?
Rick Pena for the state of Texas.
Brian Kimbrough from Mr. Navarro.
And are you Mr. Navarro?
Yes, ma'am. Yes, sir.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Navarro, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do.
State, in cause number ending in 302, are you proceeding on the indictment as presented?
No, Your Honor, we make an oral motion to amend the indictment to remove the defendant's middle name of Guadalupe. Additionally, Your Honor, we'll waive the habitual offender enhancement.
Okay.
Okay. And in cause number ending in 304, are you proceeding on the indictment as presented?
No, Your Honor, same thing. We'll make an oral motion to remove the defendant's middle name of Guadalupe from the indictment, and we will also waive the habitual offender enhancement.
Okay.
Mr. Navarro, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And the cause number ending in 02, you're charged with elderly or disabled person with intentionally bodily injury. And the cause number ending in 304, you're charged with assault family household with a previous conviction. Both of those charges are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You'll need to speak up.
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering into these pleas, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
All right, off the record for a moment. Deputy, could you all move him down to that end with his client? All right, we're back on the record. Mr. Navarro, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if the court were to follow this plea, if you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and reentry? Did you understand?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $1,500 fine. There are no applications. The cases were run concurrently. There's an affirmative finding of family violence, and there's to be no contact with the complainants. Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, sir.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand that to be the entirety of your plea? Defense?
Yes.
State?
That's the plea, yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, there be any such motion? Then in the cause number ending in 302, how do you plea? In the cause number ending in 304, how do you plea?
No contest, sir.
State any evidence.
Yes, Your Honor, with regard to both cases, they will offer into evidence case exhibit 1 of all attachments.
Okay.
All right, state, and have you had a chance to speak with the complainants?
We have, she was unable to make it today because she would like to give a impact statement, and she was asking if Your Honor would consider delaying sentence to maybe Monday so she can come in.
All right.
Thank you.
And let me ask you, is she able to Zoom in?
I can call and see if she can right now, actually.
Great, thank you.
Thank you.
Just for the record, I'm supposed to be starting trial Monday in 175th, so I'm probably not.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In each cause number, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
I would like to proceed today, Your Honor. Actually, I spoke to the DA, not that one, but earlier. She's not here now. She said that she was not seeking to have the victim impact statement, that she told the mother that it wasn't going to happen. So that's what she told me. That's why I was kind of surprised. But I'd like to go forward today.
All right, anything you wish to say? So why did you do this?
The kid was doing anonymous stupid things, and I tried to cope with me.
I'm sorry, you said the kid was doing what?
Anonymous stupid things,
What does that mean, anonymous stupid things?
touching his knees, watching him and his mom have sexual intercourse, and stole a phone from his girlfriend.
Oh, so then why are you not closing your door?
Because there wasn't a door.
All right, so then that
Yeah.
sounds like a you problem. And this child is special needs. So what have you done to this child other than put fear into this child?
I just spoke to him about.
Well, no, according to this, you didn't whip him with a belt, you beat him with a belt.
I didn't even get the chance to.
So were you employed?
No.
So this is what I find strange. You're complaining about him and you were not even employed. So how are you making money?
The job for her,
I'm sorry, what?
helping her with the job she was doing. She's a home care provider.
Oh my gosh. Just have all these random people being home health care providers. So basically you were doing nothing. You decided to get in a relationship with someone who has a special needs child. You're living off of her. You're doing nothing. And the fact that you have zero patience with this child, and for them to put in the police report that you're a stepfather, I can't even believe they would use those terms with you. You beat this child. You don't have any patience, and somebody is letting you and her be a home health care provider. And how old are you?
I'm 43.
So you're doing anonymous things like not having an employment and you're beating on a child. All right. This is what the court will do. In cause number 2025 CR 005304, the court is going to find you guilty. The court will sentence you to 8 years in the prison. There's a $1,500 fine. Credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Carlos Coronado or Andrea Graham. There's to be no residing in any household with minors. And there's to be no contact with minors. This will run concurrently with 2025 CR 005302. And cause number 2025 CR 005302. Court is finding you guilty. Court will sentence you to 8 years in the prison. Give you credit for any time served. There's a $1,500 fine. This will run concurrent with 2025 CR 005304. There's to be no contact with Carlos Coronado, Andrea Graham. There's an affirmative finding of family violence. There's to be no residing in households with minors and no contact with minors. In each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, because they're an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. So we're off the record. Here's the reason. This is why I'm doing no contact and no residing in households with children. You know why I'm doing that? Because there is somebody who had a special needs child, decided that you were a good catch. And guess what? You don't have employment. You have no means of supporting yourself. And she's probably receiving funds for that child because that child is special needs and y'all just living off that child. And Child Protective Service should be called because she shouldn't have custody of that child because she's bringing somebody in her household who has prior convictions for affirmative family violence, and she thought you were a great catch. Somebody who has no job, previous convictions, and letting them live in the home, live off a special needs child. So that is why. So that will not be happening. Do you understand? Oh, and you're dismissing this case? All right, they're dismissing the aggravated. They say that there is a missing witness. Is calling 2024 CR 2759, State of Texas versus David Villarreal. Can I have parties announced for the record for the state? Defense? And are you Mr. Villarreal?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Villarreal, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? All right. Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail facility. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
State?
Yes, Your Honor.
Defense?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections.
All right, state, you may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of evidence. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can.
Anything you wish to say on behalf of your client?
Your Honor, he's just been very cooperative and very helpful in every way, and I think he will do great on probation.
All right, Mr. Villarreal, are you employed?
Not at this moment.
All right. When's the last time you had employment?
I believe about a year ago.
All right, so how you been supporting yourself?
I do yard work, so I've been doing side job, I guess.
All right, is there a reason you don't have employment?
No, there's not. I was waiting to get my driver's license back. I got my driver's license, so I'm acting now. I'm waiting for my social security card now.
All right. Are you living with anyone?
My sister.
Do you have any children?
Yes,
How many?
5.
What are their ages?
24, 18, 13, 16.
All right, that's 4.
Yeah, I have another 18-year-old.
All right, so how often have you been using?
I have.
All right, if you drug tested today, what are the results going to be? And there's somebody here to drug test you.
I'm pretty sure I'll come out ready for marijuana.
All right, what else?
Let's see.
Oh, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 120 sober support meetings in 120 days. There's to be a TAP evaluation out of custody. If TAP recommends inpatient treatment, we'll start with outpatient treatment. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be 120 hours of community service restitution. The court is going to order parenting classes. Once you complete parenting classes, that will be deemed satisfied. There's to be field visits 1 time per month for 4 months. And thereafter at probation's discretion. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? I mean, is there a class you need? Is there something you need from the court in order to, not pick up any new cases? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as though your probation officer is not helping you or they haven't addressed the issue you have, you can always come back to court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Jesus Guadalupe Navarro walked into court thinking his 8-year plea deal was a done deal. He was wrong. Judge Stephanie Boyd didn't just accept the paperwork, she looked at the man behind it and decided to expose the truth. When asked why he committed the offense, Navarro blamed the victim for doing anonymous stupid things, claiming the minor was being disruptive and invading privacy. Judge Boyd quickly dismantled his excuse, asking why he didn't simply close a door. His response? There wasn't one. That's when the tide turned. Judge Boyd realized she wasn't dealing with a caretaker. She was dealing with an unemployed 43-year-old living off his partner who was receiving state funds to care for the individual in question. With sharp precision, she asked how he could lack patience when he contributed nothing to the household. Judge Boyd didn't stop at the plea agreement. She sentenced him to 8 years in prison, added a $1,500 fine, and imposed severe restrictions: no contact with the victims, a lifetime ban on weapons, and a strict prohibition from residing in any home with minors. Judge Boyd made it clear this predator had no business around vulnerable people. She destroyed his excuses, his freedom, and any chance of repeating his behavior.